Good afternoon, everyone, and welcome to our webinar today on Parole-in-Place, or the Keeping Families Together updates. We'll get started here shortly. We're going to let individuals trickle into our virtual space. I see we have some great attendees already, so we're going to go ahead and get started just so we have enough time to be able to answer all of your questions. Again, thank you for joining us today for our updates on the Parole-in-Place, or Keeping Families Together, most commonly referred to as the Biden immigration announcement. We'll be able to answer some of your questions today as we move along. There's been a number of updates over the last week or so, so we're going to walk you through that. But before we get started, we're going to just do a couple of housekeeping items, and then I'll pass it over to our amazing panelists from the Immigrant Legal Defense. I just wanted to remind everybody that today's webinar is being recorded, and a copy of today's recording and any of the resources that we share with all of you will be sent to your email address. If you have any questions for our panelists today, please use the Q&A function to enter any questions for our presenters today, and then we'll be able to answer your questions then. We have set some time aside at the end to answer all or some of your questions. And then with that, I will pass it over to our colleagues at the Immigrant Legal Defense to walk us through our conversation today.
Sorry about that. Thank you so much, Alonso, and welcome everyone. Thanks so much for joining us. We're glad to be able to talk to you to discuss what's happened in the past week with the Keeping Families Together Parole-in-Place. My name is Manoj Govindaya. I'm a managing attorney at Immigrant Legal Defense. Eleni, Claudia, do you guys want to introduce yourselves?
Sure. My name is Eleni. I'm an attorney also at Immigrant Legal Defense. Happy to be here with you all. And as Alonso said, please keep your questions coming in the Q&A. I'll be responding to some of them in live time and saving some for the end so that everyone can hear the responses. I'll turn it over to Claudia.
Thank you. Hi, everyone. My name is Claudia Valenzuela. I'm another attorney with Immigrant Legal Defense. I'm really happy to be here and help get information out about this very uncertain path that we're on, but still feeling hopeful about it. Thank you for having me.
Thanks, Claudia. So just really quickly about ILD, we are a nonprofit agency that provides free legal services. Among our many projects are higher education partnerships. Through those partnerships, we provide free legal services to 9 CSU campuses and 34 community college campuses. And those legal services include consultations and representation. All the services are free and confidential, and we cover sort of the gamut of immigration case types. So we've done a couple of these webinars over the past 2 months. But just to quickly refresh your memories, on June 18th, President Biden announced 2 immigration actions using his existing authority to direct enforcement of the immigration laws. The first is Keeping Families Together Parole-in-Place. And then the second was improved access to employment visas for DACA holders and Dreamers. So we're going to spend the bulk of the conversation today talking about the first one, the Keeping Families Together Parole-in-Place. If you recall from previous webinars that we've done, Parole-in-Place is a type of discretionary immigration benefit which allows somebody who is physically in the United States and entered without permission to obtain parole inside the US, which then equates to them sort of, at least according to the law, having entered legally. They've now been paroled into the US. despite that previous unlawful entry. And so getting parole in place provides a significant benefit because if the person qualifies to get a green card through a family member, they may now be able to do so here in the US, as opposed to leaving the country and needing to go through a process at a US consulate abroad. So keeping families together, parole in place is available to someone who is married to a US citizen, has lived in the US for 10 years, and all of that has been accomplished on or before June 17th of 2024. Earlier this week, a judge in Texas has temporarily stopped the program from moving forward. Claudia is going to talk about that case in a lot more detail. But, I just want to say at the outset that things are changing very quickly. This process began accepting applications last Monday, the 19th, and some applications have already been filed, some applications have already been approved, and now we're kind of in a holding pattern at the moment because of this lawsuit from Texas. So what we are hoping to accomplish today is to explain what's going on with the lawsuit and then provide our ILD's very general advice that's based on very general information. Every individual's case might be different. And, I strongly encourage you to schedule a consultation with a reputable immigration lawyer to figure out what your best options are and what course of action makes the most sense for you personally. And with that, I'm going to turn it over to Claudia to talk through the lawsuit and this judge's decision.
Yeah, so obviously, I don't think it's unexpected whenever this type of announcement is made. I think we already were anticipating that there would be litigation filed to challenge the program. And sure enough, on August 23rd, just 6 days ago, 16 states led by Texas, which has been the state that spearheads many of these challenges, filed a lawsuit in the Eastern District of Texas, basically arguing that this process is unlawful. That lawsuit was assigned to Judge J. Campbell Barker, would note, and appointed in 2019 by Donald Trump. And in some ways, we've seen a pattern of these lawsuits being filed by obviously appointees by an administration or a former president that may not be favorable to the progress of legalization in the United States for immigrants. In filing the lawsuit separately, Texas also filed various motions which essentially asked the court to temporarily stop the program from going forward. So you may have heard motions such as temporary restraining order, preliminary injunction. Those are all different types of motions that someone can file in court to say, hey, this is going to cause me harm, so I'm asking the court for now to stop this program from going forward. And that is what Texas and the other states filed as well on August 23rd. We can go to the, yes. And the basis of the lawsuit and the motions is essentially, I think many of you may already be familiar because this is the kind of argument that has been made in other contexts such as DACA or parole in place for Cubans, Venezuelans, Haitians, and Nicaraguans earlier this year. But basically the states allege that it's going to create a financial burden for them. And that is basically it will increase the health care that they must provide to individuals, education costs, and law enforcement costs. And they also do claim essentially that it will incentivize illegal immigration to the United States. And they also separately argue that, so the first part is that this is the harm to them, that's going to create more costs to them. And then as far as the law itself, they argue that you essentially cannot parole into the US someone who's already here. And separately, that a parole benefit to an individual personally does not meet the legal standard, which the legal law says it's case-by-case basis for urgent humanitarian reasons or significant public interest. Obviously, there's many countering arguments to those positions, but that is the basis of the, in a nutshell, of their challenge in court. Next slide, please. So as Manoj already addressed, the court did grant one of the many motions that Texas and the states filed, and that is an administrative stay. So it's not a full stop of the process. It is a temporary stay of 14 days, but definitely the court indicated that it will likely extend those 14 days. We do expect that it will continue to be extended through, and I'll talk a little bit about the deadlines we think will be in play. But the court, for now, allowed the filing of keeping families together parole-in-place applications. However, it ordered that USCIS cannot approve any applications during this time. It's not likely that the Biden administration will appeal the administrative stay. It's not likely that it's reviewable, but because it's so temporary in nature and it's administrative, meaning the court can, it's sort of up to the court's management of the case, it's likely not reviewable by a higher court. However, the court did set a very expedited schedule for ruling on all sorts of consequential motions and arguments in the case. And once the court rules on those types of arguments and motions, that can be appealable. And obviously the court that would review that is the Fifth Circuit Court of Appeals. Next slide, please. So there are some tentative important deadlines, which the court said the parties could seek to modify. I think that it's likely that both parties will stay on track. I think the fact that there's an election in November is kind of in the background of all of this. So I think both the Biden administration and the states are going to want to keep pressing on this litigation. And the big issue to be resolved in this case as a legal matter is whether Texas and the states have standing. That is, can they show that they are actually injured by the rule? Can they really show that they're going to suffer in costs because of the rule, costs to, provide healthcare or education or, control, like, further, in their view, unlawful migration to their states. Separately, the Biden administration, because of this argument by Texas that they are in the states that they will be injured, the Biden administration has asked for what's called expedited discovery. So evidence, they want Texas and the states to show their evidence of how they are going to be impacted by this rule in terms of an actual injury and costs to them. Obviously, the thinking is that they really can't show any concrete harm to them. And this is something that played out in another PIP lawsuit, which you all may have followed, relating to the parole of Haitians, Nicaraguans, Cubans earlier this year, which they were not successful in showing the costs. Basically, the deadline to complete the gathering of evidence, is September 16th. And the overall deadline for all the arguments to be presented is October 10th. And the court stated that it would schedule a hearing soon after that date to decide essentially all of these kinds of matters, any of these or all of these. And we may know, soon. I would imagine that the court would schedule a hearing very soon after October 10th. So it's a little bit up in the air in that regard. And we'll definitely be updating everyone once we know any next like hearing dates or anything for those who are interested, and obviously essentially know a little bit more what the fate of approvals and processing of PIP applications will be.
Great. Thank you so much, Claudia. Obviously, this is a really unfortunate development. because PIP would be a huge benefit to folks who qualify. I don't think it's wholly unexpected. I think in all of the information we've been providing to you all, I think we've mentioned each and every time that there's a possibility of litigation. So it's unfortunate, but I think at this point we really just wanna provide information on what you can do now, and what you may want to consider doing. As Claudia mentioned, you can still apply. They're still accepting applications. They just can't make any decisions on applications. So they can't approve applications, but they can still accept them. So as I mentioned at the beginning, what we can do as Immigrant Legal Defense, as our organization, is provide information and advice to you all. But again, your individual circumstances are your individual circumstances, and they may not fit into general categories of advice. So I would still strongly advise you to speak with an individual lawyer to best assess your own options. But what do you do now? What do people who qualify for PIP do at this point? We've sort of thought about this internally with our own cases and how we move forward with future consultations, future clients, and kind of separated it out into different categories of people. So the first would be for individuals who are not known to immigration. And really what that means, not known to immigration, means that a person has basically had no interaction with immigration. So they've never filed for DACA, they've never, started the I-130 process to consular process. They are here, they would otherwise qualify for PIP, but no immigration authority knows that they're here. So again, you can apply, but in our opinion as ILD, we do not recommend that people who are not known to immigration, we do not recommend that you apply at this time. And there's a couple of reasons for that. The main reason is that when you submit your application, you are affirming that you are physically present in the US, that you entered the US without permission, and you are providing your contact information, your address, and all of that to immigration authorities. As you guys may be aware, we do have a presidential election on November 5th. And it's unclear what would happen to this program, to the lawsuit, after that election. I do think that depending on the outcome of the election, it may be incredibly risky to have applied for people who are in this situation, who are not known to immigration, if the program is ultimately permanently stopped by a judge. If a certain candidate wins, then there may be a higher chance of some type of enforcement action against people who may otherwise qualify for keeping families together, parole in place. So again, if you are not known to immigration, it's our advice that you not apply at this time. Again, that's a very general, broad, sweeping advice. Your individual circumstances probably require an individual consultation. What about for people who are known to immigration? So you have been apprehended by immigration before, you have an old court order that has never been finalized, you have DACA, you have started the consular processing process. What to do? So I think, our advice is it's kind of up to you. You can apply. Anybody who qualifies can apply. There's a couple of pros and a couple of cons to applying if you're in this situation. So I think maybe the first pro is that if the program is ultimately allowed to move forward, then your application will already be on file and you will be, one of the first people in line to have your case adjudicated by USCIS if the judge ultimately allows the program to move forward. Additionally, this is a lawsuit. It's a lawsuit between the state of Texas and the United States. And so just like any type of lawsuit, there is a possibility of some type of settlement agreement. We have no idea what that settlement agreement might be, and we have no idea if there will be a settlement agreement. But a settlement agreement can include all kinds of terms. It could include something like, USCIS will be able to adjudicate applications that were filed by X date. And anything after that, they are prevented from adjudicating. So if you applied today, potentially you could be included in some type of settlement agreement. The cons of applying today, there's a lot of uncertainty. As Claudia mentioned, we think the state of Texas zeroed in on this particular court so they could land this particular judge because they're hoping for a specific outcome. So there's a lot of uncertainty as to what will happen with this program. And if the program is ultimately determined is ultimately stopped by the judge, then if you've already submitted an application, there's no way that you are going to get your money back. So you would have lost the $580 that you need to pay when you file this application. But regardless of what you decide to do, whether you choose to apply or not, we want to reiterate that it is imperative that you pursue all the possible immigration relief options that are available to you. Specific advice for DACA holders. You got to make sure you renew your DACA. No matter what happens with parole in place, it's so critical to renew your DACA, and you should never stop renewing your DACA until you have that green card in hand. Even if you submit a green card application and it's pending, you keep renewing your DACA until the green card is approved. If you are eligible for advanced parole, we strongly advise you to pursue it as soon as possible. Over the past few months, we have met with a lot of people, DACA holders, who are eligible for advanced parole and also eligible for keeping families together parole in place. Many people sort of thought maybe they would put advanced parole on hold and focus on keeping families together parole in place. If you are in that situation, we strongly recommend that you pick up that advanced parole application and move forward as quickly as possible. I'm not trying to be a pessimist, but there is a good chance that the Keeping Families Together Parole in Place program may not be able to move forward at all. And if that's the case, then advanced parole may be your best bet to try to get permanent immigration relief. And as we've been reiterating as well, DACA is very vulnerable. There's oral arguments scheduled in front of the Fifth Circuit Court of Appeals on October 10th on the latest DACA lawsuit, the latest round of DACA litigation. And if DACA ends entirely, then advanced parole ends as well. So if you're eligible for advanced parole, please, please, please apply as soon as you can. What about for those of you that are in the 601A waiver process? So the 601A waiver, for those of you not familiar, it's for a person who is married to a US citizen, but who doesn't qualify to get a green card here in the US, so they have to go abroad. When they go abroad, they might trigger certain bars under immigration law, certain punishments, for lack of a better word. And this waiver is sort of like a pardon of those bars or of those punishments. It's a provisional waiver. If you are in the middle of the 601A process, or if you haven't moved forward on the 601A process because you wanted to pursue keeping families together parole in place, move forward with the 601A process, because again, that may be your best bet to obtain status. Additionally, if you're married to a US citizen, you don't have DACA, you could get a 601A waiver in that way. And so again, just move forward. Don't delay. The other option I want to mention is related to the second action that President Biden took on June 18th, which is improved and faster access to employment visas for Dreamers and DACA holders. So the people who qualify for this are DACA recipients or Dreamers who have a college degree from a U.S. college and have an offer of employment from a U.S. employer. This has been in effect for over a month now, and it does only apply to employment visas. It does not apply to permanent residency or green cards. So to obtain an employment visa, a person has to be admissible to the United States. Applicants for employment visas who have DACA or are Dreamers who have been in the US for quite some time without permission may not be eligible to get that employment visa here, and they may have to go back to their country of origin and apply at a consulate. When they do so, they might trigger a bar or a certain punishment, and they could apply for a waiver or a pardon of that punishment. That type of waiver is called a 212D3 waiver. This waiver unfortunately cannot be applied for in the United States, and it cannot be submitted before you leave the United States. So you'd want to have the waiver application ready to go for when you get to the consulate for your interview on your employment visa. More specifically on the actual changes that President Biden made on his June 18th announcement. So he added some language to the Foreign Affairs Manual. The Foreign Affairs Manual is the policies and procedures that consular officers use when they are reviewing applications for visas. So the three specific changes he made, I put the section of the Foreign Affairs Manual that was revised. But basically, if the applicant meets the criteria that we just reviewed, a person who is a DACA holder or a Dreamer, who has a college degree, and who has a job offer from a U.S. employer. So if that person meets that criteria, then generally speaking, the D3 waiver should be approved. Additionally, if an officer who's considering a D3 waiver for someone that meets this criteria thinks there's reasons to deny it, then the potential denial must be reviewed by a supervisor. And the third change is that if an applicant for a waiver meets this criteria, then the waiver application should automatically be expedited. So it would not be within the normal processing times. So again, the basic changes are to the D3 waivers. They don't change the actual application process. They just change the criteria that an application will be decided on, and how quickly it would change. We covered the D3 waivers in quite a lot of detail on our July 26th webinar. I have the link there for you. So if you're interested in more information on D3 waivers, please look at that webinar because we went into a lot of detail on it. Sort of the last category of people is, what if you already filed for keeping families together parole in place before the court decision this past Monday, and your application is still pending? So again, under the court order, USCIS can accept applications, but they cannot approve them. So your application is pending, but it cannot be approved. We strongly recommend that you continue monitoring your case through your My USCIS account online, and that you comply with any requests from USCIS. If they contact you saying that you've been scheduled for a biometrics appointment to have your fingerprints taken, absolutely attend the appointment. If they contact you saying you need to submit additional documents, absolutely submit additional documents. Don't stop moving your case forward just because it's pending but can't be approved. It is our understanding that when the court order first came out on Monday, that USCIS determined they had to cancel all biometrics appointments So they were turning away people who showed up to get their fingerprints taken, and they were issuing cancellation notices, appointment cancellation notices. That was on Tuesday of this week. And then on Wednesday, yesterday, looks like they did an about face and determined that moving forward with biometrics is not a violation of the court order. And so now they are scheduling biometrics appointments again, and they are allowing people to get their biometrics done. So if you have a pending application, please get your biometrics done. Please keep moving your application forward. What if you're keeping families together? PIP application has already been approved. That is fantastic. Your approval is unlikely to be rescinded. There's a lot of rules in place that make it very hard for the government to take away a benefit like parole-in-place that it's already given you. Additionally, USCIS has stated that the court decision does not affect keeping families together parole-in-place applications approved prior to the issuance of the judge's order, which was August 26th at 6:46 p.m. Eastern Time. So any application approved before that time is good to go. If you are in this situation, we recommend that you apply for employment authorization immediately and apply for adjustment of status immediately. Because I think, your approved parole-in-place is part of this lawsuit, although the judge has not addressed it in this initial August 26th order. We have no idea what the state of Texas may ask for in future briefings filed to the court. And so I think you just want to move your case and your application for permanent relief forward as quickly as you can. So we're going to go through just a couple of hypotheticals just to try to illustrate some of the information that I just shared with you. So I'm currently in removal proceedings with an immigration judge. Should I file for keeping families together parole-in-place? I would refer you back to that initial slide a couple slides ago about the pros and cons. You can file now if you want to. But again, just keep in mind the pros and cons. If you have an attorney, talk to your attorney to think through the benefits of doing so. I've never had any interaction with immigration. Should I file for parole-in-place now? Again, our recommendation is no. However, you could. The court order would allow you to do so, but we strongly recommend that you not. I have DACA. Earlier this week, my lawyer said I was eligible and I'm still getting documents ready. Should I file for parole-in-place now? Again, I mean, you can, but you want to think through the pros and cons. If you're okay with parting with that $580, if that's what ultimately happens. Regardless, though, stay on top of your DACA. Make sure your DACA does not expire. And if you have not already pursued advanced parole, please look into pursuing advanced parole. I already filed for parole-in-place and I've been scheduled for a biometrics appointment next week. Should I attend? Absolutely. Attend, move your case forward as much as you can. What do we recommend you do over the next foreseeable future while this lawsuit plays out? Again, pursue every option available to you. Stay informed. You can check our social media for updates. As we have in the past, we are committed to doing a webinar or presentation of some sort within 48 hours of any major update in the parole-in-place process or in the lawsuit. And we strongly recommend that you consult with a reputable immigration attorney so you can better understand all of your options. So like I said, we do recommend that you consult with a lawyer. Why? So you can get answers to basically any immigration-related question that you have, including, are you eligible for parole-in-place? Does it make sense to apply? What are the consequences for applying for multiple immigration options? Do you have any other options for immigration relief? basically to better understand all of the risks, benefits, and options for you based on your individual circumstances. We do not recommend doing a consultation with a notario or a paralegal. And the main reason is in the United States, only immigration attorneys and only accredited representatives at nonprofit organizations have authority under the licensing rules to give legal advice and provide representation in immigration matters. Anyone who's not a lawyer or an accredited representative is giving advice or representation, most likely in an illegal way. And how do you know if the person you're working with is a licensed attorney or not? Well, nobody can guarantee approval of any type of immigration application. And no one should be promising you that they can get you a work permit fast, they can make your case go quickly, that you can apply for and receive parole in place today. And make sure you review every form and every document before you sign it. Make sure if it's not in a language that you are fluent in, make sure you understand what it is. Use an interpreter, use a translator, have your lawyer provide one for you. And you can also, the lawyer's file, your case file, is technically yours. It's your property, not the lawyer's. So you absolutely have a right to obtain copies of your file, your prior applications. Again, the legal services that ILD offers are for, or not just ILD, but there are legal services available for all Cal State and community college campuses. The services are available in your best language. They're free and confidential. They're available regardless of a person's immigration status. And they're available to students, faculty, staff, and then in some cases, immediate family members and recent alumni as well. So if you are affiliated with a Cal State or a community college campus, please take advantage of these services. They're available on every campus and they're free. If you want to receive immigration assistance, for ILD's 9 CSU campuses, we have them listed there. You can click on this link or this QR code to be taken to the appointment scheduling page. For the other 14 Cal State campuses, visit this link to figure out how to schedule an appointment with whatever organization serves your campus. For community colleges, please visit this link and you'll be taken to the scheduling page for your specific legal services provider. So thank you very much. I do welcome whatever questions you guys have. We want to make sure that you are getting the information you need to make the best decision for your individual circumstance.
Thank you so much, Claudia and Manoj, for the overview and helping people to start to think through this. Again, as Manoj mentioned, it is really important to have an individual consultation with an immigration attorney about your specific case facts. So the information on how to do so is both in the chat and has just been shared as well. There are a lot of factors to consider, as you saw from the information that both Claudia and Manoj provided. This is not an easy decision to make. So please use the resources available to you and work with an immigration attorney rather than a notario or immigration consultant, because this can have very serious implications for the rest of your future and your immigration choices. Okay, a couple questions that I think would be beneficial for the group as a whole to hear answers to. Can you talk a little bit about, if you are an individual who has never applied for anything with immigration, if you are married to a citizen and we're planning on submitting an I-130, is it better to submit the I-130 first and then apply for keeping families together if that's what you've decided you want to do, you're going to do? Or can you apply for both at once? Or do we have any advice? Or is this an individual consultation question?
That's a great question. And I think that's definitely an individual consultation question. whether it makes sense to do them in a particular order, whether there's any harm or benefit to doing them together. Um, so strategically, if you are married to a US citizen and if you are eligible to get a green card here in the United States, you normally do not submit the I-130 by itself. You normally are able to submit the I-130 and the I-485, which is the application for permanent residency. You can normally submit them together, and we call it a concurrent filing or a one-step. In order to be able to file it as a concurrent filing, you have to be eligible to get your green card here in the US. So you would need the parole in place to get your green card here in the US. So in most scenarios, I imagine anyone would say that you would probably want to submit parole in place first, get your parole in place granted, and then submit your I-130 with your 485 at the same time. However, again, I think it's really going to depend on your specific circumstances as to what order of filing would make the most sense for you.
Also, at this time, since parole-in-place applications can't be decided, it's possible that you're going to need to file an I-130 and then move forward with another process, which is a different kind of waiver, and do something called consular processing, which involves traveling abroad for a period of time. So as we said, we really advise everyone to pursue all other immigration relief since parole in place in this context is very uncertain. So this is a really good example of why it's so important to talk to an immigration attorney so you can really think through all possible options to have the best outcome of obtaining lawful permanent residency. Okay. Do we recommend that someone who is a DACA recipient who would like to pursue advanced parole do so before the upcoming presidential election?
So, yeah, I think it would make sense to do so as soon as possible for a number of reasons. The advanced parole application processing time is pretty lengthy. It's 4, 5, 6 months. So if you file today, your application for advanced parole may not be approved until, early next year. So it's unlikely to be approved before November 5th. I think the other thing is, advanced parole for DACA holders has been around since 2012. DACA has been under attack from lawsuit, a never-ending lawsuit, seemingly, for, I don't know, 8 years, 10 years, maybe. And despite going to the Supreme Court multiple times and having so many court orders against DACA being entered, advanced parole has never been something that the court has stopped up to this point. So for better or worse, it is more or less, it's kind of established as an option for DACA holders as of this moment. Ultimately, depending on what the Fifth Circuit does and what happens with that case after those oral arguments on October 10th in the DACA lawsuit, it is possible that advanced parole may end. But as of today, the best advice we can give you is that advanced parole is an option for you. And if you qualify for it, we recommend that you apply for it. But absolutely consult with a lawyer. Absolutely consult with a lawyer, because you are talking about leaving the United States and then coming back in. So you want to make sure you have somebody evaluating your individual situation and your individual facts to ensure that there won't be any issues coming back in.
Yeah, really good questions. And again, really not easy decisions to make. So important to lean on someone who's an expert to help you think through all of the options for you. For individuals who did apply for parole in place, do we have any sense of why some applications are moving at different speeds? For example, some received fingerprint notices already, some didn't.
I think that's going to depend on your individual circumstances. I'm sorry that I keep coming back to that. If you are applying for something for the very first time with immigration, then you are definitely going to get a fingerprint appointment scheduled for you. If you already have a history with immigration, if you have a pending 601A or an approved 601A, if you are a DACA recipient, then immigration most likely already has your fingerprints on file, in which case they do not have to give you another fingerprint appointment. They would be able to pull your fingerprints from the last time that they were taken and run those again for your background checks. When they do that, they don't issue a fingerprint appointment notice. They issue something called a biometrics reuse notice, which is a notification that they already have your biometrics on file and you don't have to go in to get them done again. So why some people have been scheduled for biometrics earlier than others, I don't know. It's our understanding that when this program was announced on June 18th, that USCIS went through its staff and pulled specific people from all different offices in the country to train them on keeping families together parole in place. And so it could just be that whatever officer is receiving whatever application and moving it forward in a different speed. But I wouldn't read anything. I wouldn't be worried if, the person who applied after you, if their case is moving at a different speed than yours. I don't think that's anything to be concerned about. And also, especially now with this, lawsuit and this court order, it's, there's not going to be any clear methodology at this point for how the applications move forward.
And I think that's good to keep in mind just for applications with immigration or USCIS. Generally, often will apply for the same thing on the same day for two people, and one will happen a lot faster than the other. And there's really no explanation for it. Unfortunately, USCIS is a very not transparent agency.
Yeah.
So it's hard to know. Like Manoj said, I think a lot has to do on whose desk it happens to land on for that. Alonso and Cynthia, could maybe one of you answer how people can get a copy of this webinar after?
Sure. You'll receive a copy of today's presentation along with the PowerPoint slides and all of the great resources that our colleagues at ILD have shared with you all today via the email that you used to register for this webinar. You'll also be able to find this recording as well as the others that have been mentioned in this webinar on our YouTube channel at youtube.com/@findyourally. But all of that will be shared. We'll drop the links in the chat box here and in your emails as well.
Thank you. Okay. Oh, wait. Oh, there it is. Perfect. The chat. Thank you so much, Cynthia. Thank you guys for attending with us today. Like Claudia said, this is not a final decision at this point. We're still waiting to see what happens. I think we want to remain hopeful for sure that things could turn out well for this particular program, but because it is an election year and there is so much uncertainty around it, again, it is critical to just pursue all other immigration relief and not just wait, believing that this program will ultimately lead to residency for you. So please use the resources available to you. Please don't fall prey to people making false promises to you about what this program could potentially do for you, and stay informed. Like Manoj said, we'll definitely have webinars within 48 hours of any major announcements, and through both the CSU and community college systems, there's a lot of resources available to you to use. So we hope you'll do so. Hopefully this was helpful to you all, and we'll see you soon.
Thanks so much, everyone.
Thank